good afternoon. It's me, Marian Njoroge from the Kenya Diaspora Media, and this is the Diaspora Spotlight. This is a platform where we bring you stories from across the globe, tell you how the policies enacted in Kenya affect you here in Kenya, and how those enacted in the diaspora affect you in the diaspora. Today, I have a guest in studio by the name Kevin KARUE. He is a lawyer by profession, although he is a man that wears many hats. And of course, I cannot comprehensively introduce him, so I will let him introduce himself. Welcome, Kevin.
Thank you. You've done a good job of introducing me, but I'll just reiterate. Yeah, so I'm Kevin KARUE. I live in the UK. I am a co-founder of Beacon Avenue Group, and we have several interests, primarily which is law. We focus on immigration and employment law, but we also have other divisions which include recruitment, headhunting, and my personal favorite and passion is technology. So that's me. And I've been living in the UK for 15 years now.
Okay, 15 years is a really, really long time. And I can imagine if you're a youth that's watching this, where were you 15 years ago? Please let us know in the comments where you were 15 years, because I can imagine that's been a very long time of transition. Being a lawyer, together with each and everything that you've been doing, you've seen times change, you've seen laws change, both in Kenya and in the diaspora. But for the first part of today's show, I want Kevin to tell us who he is in terms of growing up. We went to get a Kenyan picture because from the way he's speaking, are you Kenyan?
Of course, me in Kenya. I'm Kenyan 100%. 100%. We say you can acquire different passports, but where you're from never changes.
Okay.
So, I was born and bred in Kenya. I've grown up here, did my primary school here.
Which primary school?
I went to Busara Forest
Busara.
View, which is in Nyahururu.
Okay.
High school, I went to the Alliance High School, so there will be some jokes there, but we have to mention it. For me, I think in my family, we've never been focused on going to the States. So my elder brother, myself, the idea was to go to the UK. In terms of the idea of studying law, if I'm honest, when I was finishing high school, I didn't know I wanted to do law.
Okay.
But my brother's wife is a lawyer, and kind of suggested maybe you might be good at this. So when I was doing my A levels, which I did in Cambodia and Uganda at the time, I think it's a university now. So I did my Cambridge A levels there. So that's 2005 for 2 years. And then I did a mixed degree for my LLB, where I spent a bit of time between Malaysia and the UK. And so in 2010, that's to 2011, I completed my initial, what we call an LLB degree.
Okay. LOB degree in full months?
Sorry?
LOB.
Yes. So if you want to practice law, there's two types of degrees. You can do a bachelor's, for example, you can do a Bachelor of Law, or like law and criminology. So that you don't do certain core subjects which are necessary for practice of law. But if you do an LLB degree, don't ask me what it means. There's a Latin name for it, I believe.
Okay.
The same as a master's LLM. So I finished my LLB in 2011 at Oxford Brookes University. I, at that point, came back to Kenya. I spent a bit of time working with a law firm here as I was preparing to go back and do my master's. So I did my LLM master's in law, which I focused on freedom of movement, which is essentially the EU and how it was created, the benefits. So if we were to talk about Brexit, yes, I might have quite a bit to talk about that. I then, therefore, back to back, did my practice to qualify as a barrister. So that was the first thing that I did. So in the UK, the legal profession is a bit different to Kenya. In Kenya, your lawyer is both the person you go see in the office. In the UK, we refer to that person as a solicitor. And when the matters get worse and they need to go to court, your advocate. In Kenya, your lawyer is the same person. In the UK, we have a split profession, which is you have a solicitor and you have a barrister. So I first studied for the bar, as we call it, and I was called to the bar by Middle Temple in 2013. I then decided to also qualify, so I trained again to also qualify as a solicitor. And I finished that in 2014. So I've had almost 8 years of back-to-back just studying.
Okay, I would say that is a very unbreakable Kenyan spirit to love education like that and to pursue it and make it a career. It's very interesting to notice the differences in education, whereby the same profession can lead you into two different paths depending on the country that you're in. Having studied what you've studied in the UK, can you practice in Kenya?
No, so I can be a consultant, but non-practicing. So in 2014, when I finished, I actually moved back to Kenya between 2015 to 2016 for a year.
Mm-hmm.
And the purpose was to come back and see if I could complete my Kenya School of Law and so on. I think at the time, the director of Kenya School of Law was Dr. Patrick Lumumba.
Mm-hmm.
So the difficulty we have in Kenya is the Kenyan system is the constitution actually lists, or there's a law which lists, the Advocates Act, I believe, that in undergrad, in your undergraduate, you have to do a set number of 16 subjects. Now, if we compare that to the UK, you don't actually need to do a law degree to be a practicing lawyer. You can do any other degree you want to do. And then you can do a 1-year conversion course where they'll teach you the core subjects that you need to learn. So the problem we had is the Advocates Act here lists very specific subjects. So I was missing, I think, 3 subjects. Then we also had the issue, for example, it lists commercial law. Now in the UK, commercial law could be called corporate law. It could be called company law.
Okay.
But in terms of what you've learned, it's the same. So I remember having this discussion with Dr. Lumumba, and he said, look, my hands are tied here. I actually think at best, you need to be here for 3 months and then go and do your pupillage somewhere in a law firm. But there wasn't much I could do. However, because I was here for a year, I did commit. So I went to Riara to do the bridging course. I did do the 3 missing subjects, I think, that they wanted me to do.
Mm-hmm.
And I still had an issue now with the CLE in terms of giving me the clearance to proceed. And but the prospect of having to do a whole year at Kenya School of Law, having already been called to the bar in the UK, was just not
Made no
wasn't
sense.
wasn't an interesting one.
Mm-hmm.
If it's the other way around, if you're a Kenyan lawyer and you go to the UK, you can do a qualifying lawyer's transfer test. So it's actually easier for a Kenyan lawyer to go to the UK, and you don't have to do the whole either the bar course,
Mm-hmm.
which is normally called the Bar Professional Training Course, BPTC,
Mm-hmm.
or what we used to call the legal practice course, which is LPC for solicitors. You don't actually have to do that. You can actually do a QLTT test, and if you pass, you can apply for a practicing certificate.
That's really interesting. I actually expected it to be the other way around.
I think we make things difficult. In retrospect, probably the smart thing to do, and I think some friends who've done this maybe would have been finish your degree, come back to Kenya, do that, and then if you want to, then go do your masters and whatever else you want to do. To be fair, masters doesn't help you when it comes to practice, so but you could have done it that way. And I don't know too many people who've come back, qualify, and then come back to practice there. Why would you? You're happier here. It's his home,
Mm-hmm.
so. But yeah, it's a lot more difficult. And in the end, I gave up because my life started to change. My firstborn daughter was born here. So some priorities had to, when
Shift.
you look at the prospect of, well, I've already qualified there. So I've got a young family. Can I really decide to stay here, sort of working? I think I did a bit of some work with Colson Honey. I think they're Bowmans now.
Mm-hmm.
Fantastic firm, but ultimately, because you're not an advocate here,
There's really
there's not
nothing
much
much
you
you
can
can
do.
do.
So that's the challenge with the legal market here. It's very restricted. You
Mm-hmm.
look at the law firms; they do all the same thing. In the UK, you could do something as niche as environmental law, and you'll be fine.
Okay.
You don't have to do conveyancing. Here conveyancing is a bread and butter and things like that. So, I mean, some of the differences between here,
How
home,
law
and the
works
UK.
here and how the UK works. So, talking about those aspects of law, you said that you're currently practicing migration law.
Yes, so I am. So on the Beacon Avenue Group, I've partnered with a colleague of mine. His name's Asad Malik.
Oh.
We trained together. So I was employed for a long time
Mm-hmm.
by a firm called Sunrise Solicitors, which is where I really learned my trade quite a bit. I did quite a lot there. I honed my craft, and So I ended up opening their first branch office, which was in Manchester, and I was still a trainee at the time, so I was even supervising some solicitors. So we met there. Anyway, COVID came. I left I left law to do other things, legal tech. Anyway, fast forward to today. So we've created Rex Law Chambers. We provide primarily immigration services to both individuals and corporates and businesses. And immigration really is personal. So people who migrate for family, economic migrants such as skilled workers or business. And also on the business side, we advise them in terms of employing migrants, being able to have a sponsor license. And then there's always the cross section of employment issues. So your human resource, sometimes things escalate, go to court. We focus mainly on that. Recently, I've also partnered with a barrister. So as a qualified barrister, although I haven't been practicing as one until fairly, I'm only at the beginning of thinking I could go back. Yeah, because I'm more interested in the business of law rather than the practice of law. There's a difference between those two things.
That actually does make sense.
So in law school, you're not taught how to run a law firm.
But there has to be a course on economics or, you
Nope.
know. Oh, wow.
They don't teach you how to run a business. So the business of law is something I've been very interested in because many lawyers, and I think professionals, to be fair, even, for example, doctors, I don't think they teach you how to run a medical practice. But you're in an industry where people come to you because they have a problem. So you've not really got a reason to advertise that heavily. In fact, advertising is prohibited, for example, for lawyers.
Why?
Because they don't want you to, if you look at America, if you've seen the TV shows, they advertise everywhere. Now, America works different, right? When you qualify, when you do the bar, you do the bar first. First of all, you can't do law as a first degree in America. It's a second degree. The idea behind that is you're weeding out people who actually don't want to be lawyers. You want people who are a bit mature and who understand what it takes. So like if you were to sit for the New York bar, from the day you pass, you can actually practice from day one.
Okay.
So there's differences. So they advertise there because America is a whole different market on its own. Every state is different. I can't give you a reason why they allow advertising there, but certainly Kenya, I don't think the law has changed. And even the UK, advertising is restricted. The idea is you're offering a professional service. People are often vulnerable when they come to you, and they want to make sure you maintain the ethics and professionalism involved such that you're not influencing somebody's decision just because law firm X has a bigger budget compared to, say, a smaller firm.
So talking about the differences in these states, I'm thinking if you had a client, say from Kenya, from the UK, and from the US, and three lawyers converge in a room, what would they agree on?
To advise the client, or if the parties are represented by different.
Yes, like if you have three lawyers in three states, the laws are different, but you're all lawyers.
I mean, the practice of law is generally the same. There's a legal legal problem. There's an act or a statute that tells you what the rules are, and there's the experience and knowledge that we have. So if I'm an experienced immigration lawyer, I know exactly where to go and look for sign answers. So to give you an example, when we take on a client as a company as a client, they will have immigration issues, they'll have employment issues, they will have human resource issues, they could even have finance issues. So recently, I've been dealing with a company where it's a little bit of like change management. So I like to think, why have you been connected to me? There's a problem you've not solved. So if you're being sued by an employee, there's something that's broken down in your relationship, that could be fixed, if you know what I mean. So I think all lawyers can agree we speak the same language. It's just different laws, that's all, but you apply them the same.
Despite the different requirements for each and every state being different.
That's where the complexity could come. So I think it's more difficult in America because it's like Nairobi having different law compared to, say, Kericho or Mombasa. America is like that. The UK and Kenya were not like that. Laws are made by Parliament. In the UK, we don't have a constitution, so Parliament is supreme. But here we have a written constitution. So everything you want to know is written down. You can go and find what a certain law says or does. So in the UK, that's where the challenge is, because Parliament is supreme. They make laws, but the courts interpret how the law has been applied. And in immigration, we call that judicial review. We have a lot of work that we do when public bodies like the Home Office or UK Visas and Immigration get it wrong. And sometimes you get a right of appeal. Sometimes you can't, you don't, and therefore it's a judicial review.
Okay, well, that's really interesting. I feel like I'm in a law class. Does this qualify to be a law class?
Well, you are learning something under public law, which is an important thing to know, even for just various reasons, politics and others, because we all interact with public bodies who don't make the right decisions, and people often don't know how to challenge those decisions. So, judicial review is a cornerstone of legal practice, really.
Okay, so talking about laws, how has been your experience as a Kenyan lawyer in the UK system? Because it's different. As much as you didn't get to really study law in Kenya, are there certain differences in the way things are handled there?
Well, what we have in the UK is we have a lot more certainty in the system. So one of the products that the UK has marketed out there is its legal system. So many, prior to Brexit, many companies had their headquarters in London or in the UK. We have a fairly stable legal system in terms of you can initiate court action, and you don't get. I think that's the challenge we have in Kenya. For example, if you look at the size of the market of legal services, it's a very small proportion of people in Kenya who can afford, to take legal action. If let's take an example, an unfortunate accident happens, that there could be a negligence claim there. Most people, remember most of Kenya, I think over 80% live in rural areas. Not that they don't have their own financial means, but legal services are not cheap,
No, they're not.
because even at the lowest, if you went and the lawyer said my fee is 10,000 consultation, for example, for most people that's not affordable. And so you can see one of the key differences is almost every law firm here will have a conveyancing department because that's your bread and butter, you know. So that's a difference between here and the UK. So because we have the stability of systems, it means you can qualify, you can be qualified to a niche area. Like I said, you could be just an immigration lawyer, you could be an environmental lawyer, you could be a planning law. Very boring, right? All you do is planning applications, but very interesting at the same time. Each of these areas come with different types of client. Are you dealing with individuals or are you dealing with corporates? So because we have that system, you have a lot more reliability, and the standards you're held to. Every country has ethics, but there's a lot more consequences for a lot of things. Kenya versus the UK, but by and large, I think we're not too different. We have our challenges in the UK, by the way, and things have been getting worse since Brexit. Probably I don't know how much time we have, but yeah, the UK is not. Sometimes it's not what it's made out to seem. If you have a
Interesting.
country that's struggling for labor and they're having to get labor from outside, that should tell you something about how well it's doing.
Okay. No, you've said something and then you went quiet on it that the UK sometimes is not what we are marketed as. But since today we are focusing on law, what
Yes.
is the one thing that maybe people are not really aware, and how does it affect them about the UK legal system?
Um, I wonder whether it's the UK legal system as such.
Or just the legal system?
I'd probably say the country has got worse since Brexit, so it's become poorer. But Western media is very good at, painting it differently.
Okay.
So that's one thing. If somebody is emigrating, it's something you need to think about. I always say, if you're an individual or you, let's say a couple, you don't have kids, I think you'll be fine. The opportunities are there. Don't get me wrong. But for example, if you have children, it's going to be very hard and very expensive to emigrate and raise your family because you don't get help for childcare because you're a migrant, so you're not entitled to public funds.
Oh.
UK is it's kind of a socialist system where there's a welfare system. So if you don't work, you can be paid money every month. You have money for rent, you have money for bills, you know. So as a migrant, you don't get that. So if you move with kids, like school is 9 to 3, which job do you know that allows you to work for 6 hours?
No, Dan, in fact, you work double that.
Yeah, exactly. So it's something that people are not aware of. Anytime I interact with people who are moving, I always do my best to educate them and
Advice.
tell them it's not what it seems. It's not for me to tell. I'm not saying don't come. I'm just saying, for me, I'll be honest with you. I'll tell you what you're facing, particularly those who want to move with kids,
Okay.
because there's a reason why people want to move with kids, because it's one of the more fairer immigration systems. It's not that difficult to become a citizen if you play your cards right. You can do that in 6 years.
Well, 6 years is a really long time. If I was to wait for 6 years to get a residence in the UK, well, women don't mention their age, but I would be quite old. So, talking about the changes and the expectations in the UK system, there is a very contentious issue that is currently going on. And to everyone who has an interest in getting employment, there is an issue that came up last year. It's always been existent, the certificate of sponsorship issue. So I want us to start from the beginning. What is a COS? It's the one thing that people talk about, COS, this, COS, that.
So I'll start one step back. So if you want to move to the UK, generally there's three ways. For family reasons, which means you have a spouse who is settled or British, or a partner, or economic reasons. And generally, for economic reasons, we have what we call a skilled worker. So it must be a skilled job. So, for
Okay.
example, you can't recruit for cleaners. It's not a skilled job. I'm not disrespecting cleaners. It's just this is how the rules are defined. They used to, so before Brexit, we defined it as a job that is essentially degree level. Now, every company that wants to hire migrant labor needs a license to do so, and we call that a sponsor license. This is a license you apply to the Home Office or UK Visas and Immigration, and if granted, you then have the ability to hire migrant workers. So to hire a migrant worker, you then, so this is now the skilled worker. There's different types of economic categories. Skilled worker is one of them. We have global mobility. That's for like companies who have bases in different countries. So if you want to move labor, let's say from Brazil to the UK, there's global business mobility. But let's focus on skilled workers. So company A will apply for a sponsor license. They'll say, we are a healthcare company. We have a shortage of healthcare assistants. We cannot find the labor that we need, and we would like to recruit workers from outside the UK. So they apply for the license. It's granted. Once it's granted, there are two types of COSs. There's what we call a defined COS. So that's for people who are outside the country. So they work the same, but there's a distinction between the two, and there's what we have an undefined COS. Okay. So the undefined, obviously, you recruit anybody who's within the territory of the UK. So a company will then ask for certificates of sponsorship, depending on whether it's defined or undefined. When it's granted, they can then assign that to a migrant worker. Now, the COS, you have to understand, a skilled worker visa, it's points-based system, which means you need 70 points to be able to be successful in your visa. The points-based system is supposed to make it fairly quick and easy for people to get a visa. It's supposed to make it a yes or no. So either you have the points or you don't. There is no room for emotional reasons, human rights, no, because you're coming for a specific purpose. The points-based system includes students, skilled workers, all the types, business visas, all these types. So when a company gets a COS, the allocation, they need to assign it to an individual worker, because when they assign it, that COS on its own will give you 40 points. If they put the correct salary on the COS, there's a table that says what the salary is for each job. That gives you an additional 20 points. And then you need to have a minimum English language level of B1. So if you do an IELTS test, so there's what we call IELTS for UKVI. This is another problem people have faced. They do the wrong test. You have to have a minimum of 4.0 in each category, which is reading, writing, listening, and speaking. That gives you B1. Okay. For example, if there's a category Minister of Religion, so you're coming to be a pastor in the UK, the English language level is higher. It's B2.
Oh, wow. So now you've mentioned something. Let me just cut you short there. That sometimes people get the wrong test. So what is the right test to do, depending on the skill level?
So first of all, the test should always have the name particularly for skilled workers. It's for UKVI, regardless of what the test is called. So let's say Pearson is another test that's accredited. The words UKVI will appear as part of that test.
Okay.
Yeah, that's how you know it's accredited. The long story to this is, a couple of years ago, there was an English language scandal where people were sort of getting people to sit for them. So they introduced a system, a secure English language test system, where they can verify the test results themselves. So any test you do, if you're a skilled or economic migrant, just make sure the words UKVI appear at the end of that test. So if it's IELTS, IELTS for UKVI.
No, and then just a question also, because you could be having an English proficiency, because say I applied for a sponsorship and I sat for IELTS, does that mean that I have to sit for a second test to be able to work, or do the results cut across?
So you're saying if you've already sat for a test, the wrong
Yes.
test, for example.
You mean IELTS is a wrong test
You see,
for
there's
this,
IELTS general training, for example. There's no
but it gives you
UKVI.
proficiency.
It does, but they want you to do the one that they can check themselves to verify the results. So if you do the wrong test,
Uh-huh.
this is what will happen. First of all, you're supposed to get 10 points for English language. So that gives, remember I mentioned 40 for a correctly assigned COS, 20 for salary, 10 for English. You get 70 points, okay? There's one additional criteria, which is maintenance, what we call the financial requirement. Uh, you're supposed to have a certain amount of money saved for 28 days. However, if on the COS there's a box that says, do you want to certify maintenance? If your employer ticks that box, then you don't have to show any money. So the effect of that is they will cover you in the event of anything for at least 1 month.
Okay.
But going back to English, so when you're an applicant, it is your responsibility to meet the requirements of the rules. So the sponsor is only responsible to assign you a certificate and so on. They give you the COS reference number, then you go make your application. The burden is on you to make sure you've understood the rules, and that's why hiring an immigration firm could be important, but you could decide to read it for yourself. So if you get it wrong and say you do the wrong test,
Yes.
there's one of two things that will happen. They could just refuse it. You did not meet your English language requirement, we've refused the application. The COS can only be used once, which means if you fail because of that, that's it. Your COS is gone. Many employers, particularly when they're recruiting from outside the country, are not willing to give you another COS because
Because
now
I
because
can
that can't be
imagine
used, it's gone, it's
the
wasted.
cost implications.
Yes, there is some cost implications for them. However, there's what we call the evidential flexibility rule, which requires caseworkers, if there is no other reason they would refuse the application, they should give you, the applicant, the chance to provide what is missing. So it must be something that is not so critical or fatal to the application.
Okay.
Many times they will give you the chance. They will write to you and tell you have not provided a qualifying English test. We are giving you 10 working days to provide that. Generally, if you engage with them and you tell them, look, I've booked it, I can't get a date, could you please give me an extra 10 days, 20 days? They're flexible, they will. But if they don't give you the chance, strictly speaking, they don't have to. But we've had many people who get that email and they think, what are they talking about? And they just resend the same certificate, right? Thinking, but I've done the test, like you quite rightly said. The test you've done, that is the wrong one, does show you're proficient, but it's the wrong one that they don't need because it has to be a secure English language test.
Okay, that's really interesting information to have, considering how expensive these tests are.
They are.
I would argue it's better to get it right from the beginning. So, at what point does someone hire an immigration lawyer when they have a COS issue?
I would probably say you should seek advice. Well, first of all, as long as you have no concerns about your employer, once you get the certificate, it's a good time to get advice. I obviously understand the economics of having to pay for services, but that's a choice somebody has to make. So we'll probably say before you make the application, because, like I said, the points-based system, which covers skilled worker visas, it is designed to be fairly simple. Either you have the points or you don't. If you go and apply, they can sometimes decide them in 2 days or a week. There could be little that I could do if you come to me when you've already applied. So, you don't have to hire. You can pay for advice and then go do it yourself. But you would always say, if you don't know what you're doing, just ask.
Okay, that's a very lawyer statement, but it's allowed. You're a business person, as you've already established. So going back to the COS, what are some of the major changes? Because I understand we have two, especially, that have really affected people.
Yes.
And why are we calling them changes?
So I think we're primarily discussing healthcare because that's where
That's a lot of
where the major recruitment drive came from. But in theory, it covers any job that's what we call the shortage occupation list. At least that's what it used to be called, and I'll explain part of the changes that came in. So post Brexit, the UK has had a huge deficiency in very many areas of labour, so hospitality, healthcare. Obviously, during COVID, there was a huge need for healthcare workers. Construction, that's still a problem. Engineers, even in IT, there's a huge shortage. However, healthcare has higher numbers. So the health and care visa was launched in uh, early 2021. To date, I think as of last year, around just before March 2024, about 100,000 people had moved to the UK as healthcare assistants or senior carers. And those 100,000 people emigrated with approximately 250,000 dependents. So more than twice the number of the healthcare assistants. Okay. Like I said before, UK is one of the more favorable systems because you only need to complete 5 years as a skilled worker. In your fifth year, you're eligible for permanent status. Once you get permanent settled status, what we call indefinite leave to remain, in the sixth year, you can apply for a British passport.
Oh, wow.
If you get permanent status, your dependents do. So your spouse, your kids. So all of you, in 6 years, if everything works out well,
You're British citizens.
you can acquire new citizenship. The real value you get with that is it's a powerful passport. There's many places you can go. You don't need a visa. So that's what people aim for. Now, so I'm sure to date the numbers have gone up. 100,000. I'm sure it's maybe 150, maybe 200 dependents. Is where the change began. So the first change that happened in March 2024, we had two types of businesses. There's what we call agencies who operate in the healthcare sector, and the way they operated is supplying staff or labor to, let's say, a care home, right? Now, one of the rules of sponsorship, and probably should have mentioned this before, when a company applies for a sponsor license, it's not a right, it's a privilege. That's how the guidelines are phrased. The reason they say it's a privilege is because when you apply for the license, you're agreeing to take on responsibilities of UKVI in the Home Office, in the sense that you're going to help them monitor the people that you have recruited, because they cannot possibly do that. So it's a privilege because you have been made aware of the guidelines. There are basically four main sponsor duties. And by applying for it, you agree that you're going to be responsible, you're going to follow those duties. And so therefore, at any point when you're audited, they expect to see that you are complying with those duties. So one of the key rules is you must be directly in control of any migrant workers. Directly in control means you train them, supervise them. You're the one who tells them what to do. So the business A that was an agency was allowed to get a license because when all these companies applied, nobody was really checking what's the difference. I don't think the Home Office knew what's the difference. And the difference is simple. An agency supplies labor. So you could have a company and tell me, I have a contract with a care home. I'm struggling for staff. Could you supply me some staff? So I will send my staff to you and you send them to somewhere else. Would I know what they're doing?
No.
I don't, because even you don't know what they're doing because you sent them to the care home. Now, the other kind of healthcare business is regulated by the Care Quality Commission. That is different because they're regulated because they directly provide personal care services, which means they have a registered manager who's registered with the Care Quality Commission, CQC. And so if anything goes wrong, so they directly control and train and they send people into people's homes. In Kenya, we look after our parents. We don't send them to a care home. At least I know they're coming up, but generally most people, our culture, that's our culture. In the UK, like in Europe, the culture is different. So the state will pay for the care for the elderly. So a company that is regulated by CQC will send healthcare assistance to a person's home several times a day. So they'll come in the morning, help you get up, wash, bath, change, that kind of thing. Then they'll leave and they'll come back at 10, then they'll leave, come back at lunchtime, come back 4. So this is one area we call domiciliary care or home care. So the point I was making before is an agency isn't regulated by CQC because they're not actually the ones providing personal care. They're sending staff to a CQC regulated business who then that company is responsible for personal care. So in March 2024, the UK government decided anybody operating in healthcare must be CQC regulated. So that was the first major change because now that ruled out a lot of companies who could now no longer hire healthcare workers because they're not going to get a license and they're not going to get any sponsorship certificates. The other change came in on the 5th of April 2024. And that one then removed the right for care workers So we have two codes which represent the workers who've moved: 6135, which is care workers, previously 6145, and 6136, senior carers or senior support workers, which was previously 6146. So they removed the right. So that meant any COS assigned after the 5th of April, you cannot have dependents. So that cut off the ability for people to have dependents. Anybody who had already been in the UK prior to that date, you can continue having dependents. So you could be a person who moved to the UK, but you never brought your family. As long as you came before 5th of April, you can bring them at any time. But
Okay.
if you are in the country, let's say you're a student, you finish your studies on the 15th of June, 2024, you then get a COS. Because that COS is assigned after the 5th of April, 2024, you cannot have dependents. The same also applies if you are a skilled worker. Let's say you came as a construction worker and you decide, I want to switch to care, but you came with dependents. If you're assigned a certificate after 5th of June 2024, your dependents can stay with you, but they won't be able to extend. So, the immigration system is quite complex,
It's
and
quite, yeah.
it has a lot of nitty gritties, and the UK government always gives us the challenge on making it complex, to be fair. So
Okay.
those were the changes last year. This year they have now changed it further, which now unfortunately makes it difficult for companies to recruit from outside. So the new rules, unfortunately, we've had a lot of companies who've lost their licenses,
Okay.
which is what we call revocation. And what that means is when a company loses its license, eventually the workers who are under them will have their visa cut short, curtailed, as we say.
Wow.
But it doesn't happen that quickly, to be fair, because there's been a lot of people displaced. There's been a lot of companies who've lost their license. We do compliance work. Even beginning, we advise these companies this is what you're supposed to do and so on. But as you can understand, I can give advice, but I can't make somebody
Make
do
you follow it.
what they do. Sometimes it's very unfair how some companies lose a license. It's not cheap to fight it. In as much as we also help with that, but there's been a lot of workers who've been displaced. So on the 9th of April, they've now introduced a regulation to say any company looking to hire new care workers, right, whether they're from outside or whether from inside the country, you have to show that you've engaged with your local, they're calling them regional partnerships.
And made sure you've
So what
exhausted.
happens is, let's say I live in London, there'll be a regional partnership where people can register and say, I'm displaced, I'm looking for work. So if you have a company in London, before they can recruit a new person, let's say it's a student who wants to work for them, maybe they've been doing part-time work for them. Now they will have to show, we checked in our local partnership, we
And
couldn't
didn't
find
find
a suitable
anyone.
worker, so we want to hire this student. Okay, so they're trying to make companies absorb the
The
people
local
who have been
market.
displaced. I see two problems with this.
Yes, yes, yes.
There are many companies who still haven't been inspected. They haven't been audited yet. So the same companies you're forcing to absorb displaced workers could very well end up being the ones who lose their license. So I don't really think we're solving the problem there.
Okay.
So if a company's not been audited, and let's say they absorb 12 workers today, 6 months from now they inspected, then they lose their license. You see, it's almost a tautological cycle of displacement that will continue.
Well, that's interesting. Although whatever is happening, if whatever happened on 9th of April, I think there was something about it last year. Like the ground was set for it when those laws changed, because you had to prove that you cannot find care workers within the
No,
UK.
there wasn't. No, I think what happened is they slowed down on granting companies the COSs to recruit from outside. So we have this problem because from around October 2023, the statistics I gave you about the huge numbers, particularly dependents, the previous government, the Conservative government, who are now out, the first thing they did is between October 2023 coming up to around March, it was very they kind of stopped deciding any applications for COSs for companies because they needed to introduce the law to restrict dependents. There was too many dependents coming in. Okay, UK is an attractive country because you see, like schooling is free,
Yes, yes, yes.
healthcare is free
It's also
because
free.
these healthcare workers, well, if you're a normal skilled worker, you pay something we call the immigration health surcharge. It's very expensive. It's 1,035 per year of sponsorship.
Oh,
So
wow.
a normal skilled worker visa would cost you maybe 3,800, but health and care workers only need to pay the visa fee. So the government from October 23 up to March, they had really slowed down things to essentially, because if you told people the law is going to change in March, what do you think would happen?
They find a way to just.
There'd be a huge rush by companies to get certificates, recruit. So they wanted to stop that.
Okay.
So, and even after April, because they did change other things, they changed, so the shortage list now became the immigration salary list. They just, what they did is really just slow down the process. So it's not that companies had to prove anything. They just slowed it down. Again, there was a lot of abuse that came up as a result of that. Companies who have recruited, there's no work, that kind of thing, losing licenses. So they just really slowed down. I'd probably say maybe from July onwards, you started seeing some maybe, but also some didn't want to recruit because they're like, we don't know how well we're doing audit-wise. So that's why you've seen the numbers have trickled down and gone down.
How often does the audit happen?
It depends on what triggers it.
Okay.
Generally, every 2 to 4 years, you should have an audit. But if it's triggered because of whistleblowing, or maybe it's a random check, it just depends.
It just happens. So talking about also this COS issue, because I think this is a conversation that is still going to grow depending on other changes that happen and how they affect people. I know that there are people who are fighting it through
Okay.
Parliament. Do you think like that's a good idea, or
Do you mean the companies or who?
no, like there are certain individuals, even like politically, who are fighting the issue of COS and the changes that have happened?
Well, the reality is there's nothing they can do about it, because the only way you can challenge a decision, you see, the UK Parliament is supreme, which means, and the way the Home Office works, it works under what we call delegated responsibility, which means the Home Secretary, who's responsible for immigration, does not need to take any specific rules, right, to Parliament for them to be approved. So it operates by what we call a negative approval procedure. Unless somebody objects to something the Home Secretary wants to do, any rules the Home Secretary wants to pass almost always pass. If you have an issue with the rules, right, and because keep in mind, I call them the rules, they're not actually statutes, they're rules. So they don't have the same status as an act of Parliament. So the Home Secretary can pass whatever he wants to pass, okay? If you're affected as an individual, you'd only be affected in one of two ways. You've made an application, it gets refused, okay? You then challenge it through what we call administrative review. So there's no right of appeal because the points-based system doesn't come with the right of appeal. If your administrative review is not successful, then your remedy is to go for what we call judicial review. So you can't have a politician go to I don't know.
That's really
the court
interesting
system is where you
because-
challenge these decisions.
That's interesting because there are politicians who are telling people that they're fighting the COS changes through Parliament.
No.
Oh, wow, okay.
No.
Okay.
Well, I'm not saying they might not be speaking to various MPs and so on. I mean, of course, you can lobby your local MP. So you can go to your local MP and say, we don't like how, there's so many people who are affected. I think the biggest problem the UK has is, and I think I've written a paper on this, when you're sponsored by a company, you can only work for that company.
Interesting.
Mainly. You can then only do an extra 20 hours with a company that, as long as it's a skilled job. So there are many people who came who are not healthcare workers by profession, right? If you then lose your job, I could be, for example, a media person, like you, for example. You could find opportunity in a media company, but that media company may not be willing to apply for a license because they don't like the scrutiny that comes with it. So then you can't do the job that the UK could need. There could be people who could do construction work, but construction work companies, some would say, well, we don't want a license. So because the skilled workers system operates that you cannot just do any job, you have to be sponsored to do a specific job. This is why there's loads of displaced people who are now all going to be waiting for healthcare jobs. And if I'm honest, most people who have come are not good healthcare workers. Not because that they can't be, but for example, the company that brought them didn't have work, so they were never trained. Maybe, the industry favors women, so there's loads of men who can't get work. They don't have a driver's license. To do domiciliary care, ideally you have a license and a car. So you're going to end up with loads of people who have other skills they could offer the economy, but the way the skilled worker system is designed does not allow them to provide those skills to the system unless it's only 20 hours a week. But you can only do the 20 hours if you're doing your main job. There is another visa that works differently. So if I was lobbying an MP, I would be saying you need to change how the skilled worker route works and allow people to do any job, okay? As long as they're working, the UK economy benefits that way.
Okay. Well, that's really interesting, and this is a very contentious issue because a lot of people leave Kenya with a particular mentality and thinking a particular way. But of course, there are myths and misconceptions around the COS and how it works. Maybe we are supposed to wind down, but that is something that I feel is really, really important. What are things that someone should watch out for? Because it would be very unfortunate to land in the UK and realize that you can't stay here because your employer either didn't do due diligence or, like you said, their license has been withdrawn.
I think the misconceptions or errors, as I would say, have been seen on both sides, both on behalf of both by companies or employers, and also by the workers who've come over. Probably the easier one to start with is companies. There is no way of knowing if a company is compliant with their sponsor guidelines, because when you get your license, yes, it's published on the list. So at best, you can check if they still have a license. So if you're being purported to be sponsored by a company, you can go somewhere online and you can check, are they on the list of registered sponsors?
Even with a lawyer, there's literally no way
No,
around it.
because the sponsor guidelines are contained in PDF documents. They're not. How will you know if the company is complying with their record keeping duties? So one of the sponsor duties is recruitment and record keeping. That basically says when you recruit people, if you end up hiring them, you must keep every piece of document from the beginning. You hire them, and then you do other things like monitoring immigration status. As an outsider, even me as a lawyer, how will I know that you've been doing that? Only if you give me insight to your system. Now, if I have a company as my client and they've assigned you a certificate, even if you ask me how compliant are they, and I'm aware of something, my duty of confidentiality, I cannot tell you that. I can't tell you something that, because my instructions are to help company A, say, with their compliance duties. They will also, some companies will say, okay, could you also help this applicant apply? It depends on what I know. But even if I did know something, the
You
only thing
wouldn't
I can
tell
do is
me.
if I know a certificate of sponsorship is not legitimate, then I can decline instructions. But
Oh.
it's not that easy to tell, right? We don't have clients who are like that, but it's very difficult to know how compliant a company has been. For example, another duty, monitoring immigration status. How will you know if they've been doing the correct right to work checks? That information belongs to the company. This is why, going back to a moment earlier, I said the way sponsorship is defined, it's a privilege. It is, the onus is on them. They decided to apply for a license. In doing so, they agreed that they have read the guidelines and they understand what they're supposed to be doing. So if you are being offered a role, the basic thing you can do is to confirm that they're on the list of registered sponsors, because there are some and fake agents out there who present you with fake COSs and things like that. You can at least check, are they appearing on the list of sponsors? That's one thing. To recruit people from outside, it must have an A rating. So we have two ratings, A and B. The difference just means if you're B rating, you can only recruit from inside. And usually that tells you something's not gone quite well if they have a B rating. So they've been not revoked their license, but they've been told, okay,
You can only
fix some
hire
things,
from
but you
there.
can only recruit
So
from
where can you
inside.
find this information if you were to go
It's on
online and
gov.uk,
look?
but if you just Google UKVI Register of Licensed Sponsors,
Oh.
it's updated, I think, every day. So it will open up a huge sort of CSV document spreadsheet type. You can just search and you can search the name of the company. If you find it, at least that will tell you that it's live. We are working on a digital platform for Rex Law Chambers and expert legal help to create a link on our website where you can just go and search. So we're trying to link it to the government system and see whether there's a company that's done that and we want to do something similar. So we
Okay.
want to learn from our competitors and offer something similar.
Oh, interesting. So, what happens when someone finds themselves stranded in the US, not in the US, in the UK?
In the UK, yes. So this will tie in quite well. I think I did know this conceptual companies. So mistakes by applicants is a failure to upskill yourself.
Okay.
Okay. The most common is failing to get a driver's license. If you've come into healthcare, this job requires you to drive. Even if you don't have a car, some companies have cars, but you need to be able to drive. So when you first came in, you can only use your license, your foreign license, for 12 months. Okay.
The foreign driver's license.
Yeah, some countries like Zimbabwe are allowed to exchange it immediately, and they get a full license straight away. Don't ask me why Zimbabwe,
Come
and
on,
maybe
Zimbabwe,
I,
really?
I mean, I'm not saying there's anything wrong with Zimbabwe. I'm just saying it's one of the few African countries that can do that. If you come from the UAE, you can also exchange your license straight away. But everybody else, you only have 12 months to use it. So it's a common thing I've seen. Keeping in mind the industry favors female carers or women as carers, there's too many people who don't have a license. So that's a mistake. You have to upskill yourself. If you find yourself stranded, it depends on what's happened. If your company loses their license, the Home Office are not being very quick to curtail or cut short your leave or your visa. It can take anything from 6 months to a year, sometimes even more.
Okay, so you
But
might.
when eventually they do, they will give you 60 days. So you could end up staying a year and then you get the letter, then you now have 60 days. So you could end up staying a year and 60 days, a year and 2 months. All this time still counts, by the way. So if in the end you find another sponsor, it still counts towards your 5 years.
Oh, really?
Yes,
That's
so you
interesting.
don't. Yes, it still counts because you still have leave to remain. You still have right to work during that time. What you don't have is a sponsor, so you can still work. Okay, it's a gray area because the rules don't say can you work full time, can you not. The advice we give the companies is, well, when they've lost their sponsor, the best thing to do is take somebody on as soon as possible because strictly speaking, they should only be doing 20 hours, but it's a gray area. Okay. But when eventually you get your 60 days, now the clock has started ticking. The basic rule of thumb that I advise everybody is you must submit any application on or before the last date. Even if you know you don't qualify for that application, you are better off submitting that because that keeps your right to work intact. And that means eventually when you find a sponsor, they can take you on. If you don't apply before your visa ends, you now go into what we call from midnight, you become an overstayer. And now you only have 14 days. If you were to submit an application within those 14 days of overstay and that application succeeds, they will not look at those 14 days, they'll disregard it. But once you go beyond 14 days, at least as a skilled worker or the points-based system, there's nothing that can be done. And you must have something exceptional, like maybe you were hospitalized or something like that for them to consider discretion. Even if there are children involved, they will not look at it. The biggest mistake is you lose your right to work. Unfortunately, I've met loads of people in this situation where either people have misadvised them, sometimes even family, and they just fail to apply in time. So, the it the options are not there. If you overstay more than 14 days, unless you find a different category to switch to. For example, you might go and fall in love and find a settled person. You can switch categories, but your
Within 14
time starts again. But you could, But for most people, that's not the reality.
Okay.
As an economic migrant, if you stay more than 14 days, you can keep staying, but eventually they'll catch up with you, they'll remove you. And once you've overstayed for more than 30 days, a 1-year ban applies in terms of re-entry. And if they remove you at their cost, that becomes 2 years. The ban gets longer and longer, but
Okay.
it's not a system we agree with as immigration lawyers. We think it's too harsh, particularly because employees are not at fault for the mistakes of their sponsor. Like I said to you, how would you know how compliant a company is? They don't even publish when they've been inspected.
So how then does an employee protect themselves? Because it feels like a lot they're at the mercy of the employer. How do they ensure that they're safe?
I would say everything in life has a risk, and too many people have come on this route without. There's a risk. It's just the risk you take, because it's your choice to move to the UK. Nobody forced you. Nobody's asking you to. It's your choice. So it's for you to look at the risks and decide to take it.
Okay.
But probably also be wary. There's a lot of immigration boards that put a lot of false information. And then, people do the classic thing, oh, I know somebody who did this, so it's going to work. I'm like, if you had a medical problem, would you go and listen to somebody who said, oh, let's try this witchcraft thing, it's going to work? Or would you listen to a professional? You can find any professional you think you trust. Okay. Again, it's your job to determine if you're hiring a good immigration lawyer or not, or lawyer, whether it's not immigration only. I would probably say get the best advice you can. That's the only way you can mitigate your risk. So if you can, get the advice before you come, and whilst you're there, get the advice before your time runs out if you find yourself in a situation.
Okay.
Yeah.
Thank you very much, Kevin, for your time today. As we went down, I would like you to answer one question that will conclude this interview. Any message to policymakers and individuals who actually sit at decision-making tables? Because this has had a lot of consequence for, even if not in Kenya, a lot of migrant workers are affected by these changes. What will be the best way forward? Because it'll keep
Yeah.
happening.
Yeah, so pre-Brexit, it was actually very difficult to hire. Sponsor license has been there for ages. People think it's a new thing. It's been there since, I don't know, it's last more than 20 years.
Okay.
But before Brexit, it was very hard to hire migrant labor because there was a very different system that applied. Post-Brexit, the country is not doing too well economically. For whatever reason, the local population does not want to do some of these jobs, and therefore that's why the need has been there. The best way that I think could be an option is to maximize the resource that you have. And migrant labor is a very valuable resource. My African brothers and sisters are very hardworking, wherever you come from, whether you're from Ghana, Nigeria, South Africa, because we know of the challenges we have in Africa where systems don't work. People have grown up more hardened, which means given opportunity, most people actually do the thing they're supposed to be doing. There's a route, which is also a points-based route called the scale-up worker visa. Okay. And it works as follows. For the first 6 months, you're tied to your sponsor. After 6 months, you don't have to.
That's
Okay.
interesting.
But when the time comes to extend your leave, if you're not tied to your sponsor, you will need to meet an income requirement. So you'll need to show you meet a certain amount of salary that you've earned. And as long as you do that, which means, so for the first 6 months, you'll have to do whatever the sponsor has brought you to do. But after 6 months, you could decide to leave and do whatever job you find. And as long as you meet the income requirement, you'll be able to extend your stay.
Okay.
I think the skilled worker route is too restrictive because the UK needs a lot of skilled labor, and it needs to open it up so that people can actually provide the skills that they have where it's needed. You've got journalists who are working as carers. Okay, they came in, but if they don't have work, why should you stop them from doing what they can provide? You have construction workers who are there, but they don't have somebody to take them on because they're restricted. If you open it up, then companies can now start recruiting the labor that they need. So the dependents are the ones who've been winning in this, the people who come as dependents, because dependents can work in any profession. But don't forget, out of those 250K dependents, a huge amount of those are children. So they can't work.
They can't really work.
So I think to me, that's what needs to happen. They need to open it up and make the most use of the labor that's coming, since there seems to be an idea now to change it. If they do that, then I think, then yes, although it will mean less opportunities for people from outside, potentially, definitely means the people in the country can be less panicky and they can do well.
Okay, that's really interesting. So it has been a very interesting session with a lawyer, Kevin KARUE. He is an immigration lawyer and an expert in all things immigration. He has a law firm. We would leave the details of his law firm and what he does in the show notes of this particular show. Continue following us on all our social media platforms, the Kenya Diaspora Media, the Diaspora Spotlight. Thank you very much for tuning in today, and I look forward to seeing you in our next episode. Kwaheri.